Escalating violence by ICE in Minneapolis and across the country has raised the question of whether states can criminally prosecute federal officers. The short answer is yes, but it's complicated. I'm Alicia Bannon, a constitutional lawyer. Here's what you need to know. Despite claims from the Trump administration, including Vice President J.D. Vance, there is no absolute immunity for federal officers from state criminal law. Instead, these cases are governed by something called Supremacy Clause immunity, which comes from an 1890 Supreme Court case called In re Nagel. In re Nagel, a federal marshal shot and killed someone who attacked a Supreme Court justice. The court said the marshal couldn't be prosecuted by the state because he did no more than what was necessary and proper to do his job. That phrase matters because when federal officers act outside of their official duties, or when their conduct is unreasonable or unlawful, states have the power to prosecute. Courts have allowed states to prosecute federal officers before, including soldiers who shot a civilian already in custody, and an FBI sniper who was charged with killing an unarmed woman during the Ruby Ridge standoff. If Minnesota or another state proceeds with a prosecution, federal officers could move the case to federal court. State prosecutors would still run the case, but federal judges would decide the question of immunity, and it would likely be a long process. But if a conviction happens, it's for a state crime, and it cannot be pardoned by the president. So the message is clear. Federal power is not unlimited, and states have tools to hold federal officers accountable. Sign up for State Court Report's free newsletter to stay informed.